All right, good afternoon. I know this is a little weird because you all can totally hear me, but we are going live today on Facebook on the Ninth Circuit FL. So welcome everybody who might be watching on Facebook. If you'd like to send questions, you can send those to hashtag DOR SEMOSC. I'm Diana Tennis, Circuit Court Judge, and I will be moderating this conversation that we're going to have today related to DOR and child support issues. There is 1 hour of CLE that's been approved for this course. I'm going to give you the number right now, and then I will try to remember to do it at the end. If you are not on the mailing list, meaning if you are not getting emails from my office related to seminars with attachments of the materials and things, please contact my judicial assistant, Karen Wynn. If you miss or miswrite the CLE number, also contact us and we'll get that to you. So the number is, I'm going to give it at the end also, 170-291-4, N as in Nancy. That's 170-291-4, N as in Nancy, and I will try to say that at the end. So today we're here to talk about DOR and child support issues. I have Norberto Katz, who's a child support hearing officer, to help us, as he always does. Thank you so much. And I have Hernan Castro, who's an attorney and works with DOR and represents them in child support cases and paternity actions and things such as that. So one of the things that I'm seeing a lot in my courtroom, in general, there's confusion because it's a confusing area, but one of the things that I really want to make sure that you leave here today knowing how to figure out better and more quickly when it is that DOR is enforcing child support already in a case that you're getting involved in, so that you'll know the proper course of action. How to distinguish between paternity actions that are brought by the Department of Revenue seeking child support, dealing with child support on behalf of either a plaintiff or a respondent, and what kinds of situations that might come up. And then the child support administrative orders under 409.2563, which are an entirely different beast and get dealt with in a different way. So I'd like to start by talking about my perception is the most common type, which is, there's 2 rows up here too. Nobody ever wants to sit at the front. Everybody's like way in the back. Everybody, you can come up front. We've got lovely rows up front. Nicely done. So I think the type that come up a little bit more often are when the Department of Revenue gets involved on behalf of a party, usually the person wanting child support, and they file a petition to establish paternity and get child support, and we're going to call them a DOR case. And so, Hernan, I'd like you to talk just a little bit about the kinds of situations where a department will get involved for somebody and how the lawyers might figure out that there's a department involvement when they go to file a paternity action or a divorce action on behalf of either a mom or a dad.
Okay. The Department of Revenue provides Title 40 services. Those are services which are prescribed by Title IV of the Social Security Act. Automatically, when someone goes to DCF and applies for food stamps, Medicaid, cash assistance, any one of those 3 services, or when a child is in foster care, there is an assignment of right, which happens by operation of law, to the state. The agency that enforces that assignment of right is the Title IV agency. And in this case, in the state of Florida, by virtue of Florida Statute 409.2551, that agency is the Department of Revenue. It used to be HRS in 1994. It changed. That is one type of case, and that is a case in which there is an assignment of rights by virtue of the fact that the child is now receiving assistance from the state. The other type of case that we have is when someone just walks off the street and says, I've got a child and I would like to get a child support order. Now, the statute, Title 4D, was expanded in 1974 to provide services to someone who just walks off the street and asks for services from the Department of Revenue. And there need not be an assignment of right. The department is required by federal law, and we have about 55 to 60% of our cases are non-assignment cases. The person is supposed to pay a fee to the Department of Revenue, which is stipulated by the statute to be $1, and which the department waives. A lot of times, I get these questions from attorneys. Why are you involved in this case? She's not getting any benefits. It's none of your business. Why are you here? Well, we're here because she has asked for services under 409-2567, and we are required to provide those services, and there is not a means test. It does not matter what they make. We have to provide those services.
So let me ask you a question there, and feel free to ask questions throughout. In that situation where mom comes to you who is not getting assistance of any kind and wants you all to help her get child support, is that still technically a Title 4D case?
Yes, a Title 4D case is any case in which the Department of Revenue is involved. There are a couple of recent cases that talk about that. Spano is one of those. Spano versus Bruce is part of the outline there. It simply stated the department does not have to intervene in a case. The department does not have to ask for permission to get involved. If they qualify for services in the Title 4D and the department gets involved in the case, it is a Title 4D by definition. And there are a whole bunch of consequences to that designation.
So if a person who is getting services from the state is assigned to you to go out and seek child support in order that the state get some recoup of their money, or somebody comes to you seeking your services and getting them child support, if there is no pending case related to that family, that mom and that dad, what do you do and where do you do it?
It depends. The agency has two avenues now to use in cases such as that. One is an administrative process on the 409-2563, and I will talk about that later on and tell you exactly how to identify one of those cases. The other type of case is a traditional case. Now, those are both Title 4D cases, but they are different. One is administrative through 409-2563. The other one is actually a judicial case where I come to court. That case is referred to my office. I file a pleading with a court, a traditional pleading, a complaint or a petition. I issue a summons. And then after that, after obtaining personal jurisdiction, we begin to try that case. And then we litigate that case only on Title 4D issues, which are, unless the governor signs legislation that's pending now, it's only on the issue of paternity, establishment, and enforcement or modification of child support.
Now, if there's already a divorce or paternity action pending between the parties, would you ever go that same route and file that paternity action, or are you always just going to get involved in the litigation that's already ongoing?
If there is ongoing litigation between the parties, and especially if there is an assignment of rights, say mom and dad are getting divorced, mom's financial situation or dad's financial situation is such now that they need support, they go to DCF, there is an automatic assignment, and then we go in and get involved in litigation, and normally we filed a motion to intervene and to establish child support. And we do that so that we can start getting some money flowing in to ameliorate the food stamp drainage and the Medicaid and all of that stuff.
All right, so let's talk about the situation first where there is not already a paternity or divorce case pending. Somebody has sought services from the Department of Revenue to get child support, and they file a paternity action. That paternity action goes to hearing officer Katz.
Correct.
So tell us just a little bit about that process.
So the process is basically Mr. Castro files his petition, parties are served, and then a trial is set on those issues. And we're talking about now original cases as opposed to contempt. I want to make sure that we cover that. And then I have one little added comment to something that Ms. Castro said. That matter is then, Mr. Castro then files a notice for trial, or sometimes I do get a notice for trial from opposing counsel, if there's opposing counsel, and then we set it on a docket. Normally Tuesdays or contempts, Wednesdays or originals and modifications, but that may vary a little bit, and Fridays we do motions. So we set a trial, and we schedule the trial, and then parties come in, and we have a fully contested trial at that point. One point I wanted to make is that in a perfect world, is kind of the point that Judge Dennis was starting to make about you've got to be careful if there's a pending case. Sometimes, and I'm not saying all the time, the parties don't let DOR know that there's a pending case. So that's a trap that you really must look into, and if there is a pending case, you need to let me or Judge Dennis know so that we're aware of it, because many a time, and this has happened, and it's not Mr. Castro's office's fault because they're not aware of it, because they get their information from DOR, who got it from the litigant, and they don't tell them there's a divorce, or they don't tell them that subsequent to the paternity action they filed a divorce, and all of a sudden we get to a hearing and we find out that there's a pending dissolution or another action. So it's always good as a practice procedure if you're in that situation to check. Just wanted to let you know about that.
So say, for example, mom goes to DOR, DOR files the petition to establish paternity, and it gets served on the respondent, putative dad, and dad files a motion, hey, I'm not the daddy. I'd like a test. What happens then?
Well, under the statute and under the rule, that is now a contested paternity case, which I cannot hear. So that has to shift, at least temporarily, to the judge to deal with the paternity issues. And once those are resolved, then to come back to me for child support. So the motion for paternity testing would then go before the circuit judge. There would be a hearing. Mr. Castro would appear. The litigant would appear. And if paternity is an issue, most times as a practice tip, the department's very easy to work with. If they see there's a paternity issue, then the paternity aspect is done, and then if he is found to be the father, it comes back to me. The problem is that many a time people don't really understand. I believe it's 764, Ms. Castro, you can, on the statute, and this is a point that we really need to make also while we're talking about this. Paternity is established by an acknowledgement of paternity or by being on the birth certificate under Florida law, and you have 60 days to contest that. So many a time I get people that say, oh, I found out I'm not really the dad, or she told somebody and now I want a paternity test, after that's all been resolved by way of being on the paternity, by either having executed a paternity affidavit or being on the birth certificate. So you need to understand that when you get a client in that perspective, and I tell people this, the only avenue is a disestablishment. So you need to deal with that early on.
I want to really, really underline and highlight and circle and put little arrows toward this. If dad is on the birth certificate, that meant that those parents signed an affidavit at the birth saying he's the dad. If they did not file a rescission within 60 days, and they didn't, they never do, then he is legal dad. He cannot ask for a DNA test. He must file a petition to disestablish, and it must be not in that paternity case. It has to be a totally separate civil case. I've had this happen so frequently, like 3, I think, in the last week, is folks filing petitions to establish paternity and asking for DNA tests. No. 742.18 has very specific things that must be alleged to disestablish. One of those being you have to be up to date in your child support. So if somebody filed erroneously a petition to establish paternity when they were really trying to get out of being the daddy, and they miraculously happened to hit everything that was in 742.18, I can envision a scenario somewhere where I might be okay with that, but it never does. And so the bottom line is you don't get a blood test. You do not get a DNA test. if the parties are married during the conception and birth of the child, if they get married after the birth of the child, because there's a statute that says he becomes daddy then, and I think the time frame there is fairly important. If the child's 7, I think that's arguable. That's a different situation. But the one that comes along the most often is he's on the birth certificate. If he's on the birth certificate, he is dad. He needs to disestablish. And so typically what would happen is I would get a petition for DNA testing. I'd look at the file. I'd see child has the same last name. I'd go right to the birth certificate, or I'd require the parties to file a birth certificate. Sure enough, he's on there. He doesn't get a blood test. And then he can, if he wants, file a petition to disestablish in circuit court, which would be dealt with by me. So the kinds of cases that we've been talking about so far, where the department files the paternity action, it goes to the child support hearing officer. That is now a Title IV-D case. I, as the sitting circuit judge, am not authorized to deal with setting child support, changing child support, or enforcing child support. That is solely the purview of the child support hearing officer. Now, how many of you do some practicing in Orange County? All right. Just because I'm concerned that you might not be confused enough, I'm gonna give you, I just did this seminar in Orange County last week. I'm gonna give you the 10-second Orange County wrinkle. It is apparent to me that up there, assuming there's notice to Department of Revenue in your paternity or divorce case in front of the circuit judge, assuming there's notice, and the department has a chance to intervene, get involved, object, whatever, they do appear to be entering, I'm going to call it superseding orders related to child support. Now, I will tell you that the lawyers told me after our seminar that this is causing all the problems that we know it causes, which is why we don't do that down here, and that is the clerk is not getting the DOR case numbers changed. And now you've got 2 orders and 2 different cases, both being enforced. You can have dueling income withholding orders, and it's become problematic. There may be fixes for that up there. Our fix is to follow the order that we've been given, which is all of those issues are dealt with by the child support hearing officer. Now, I want to go back, Hernandez, something that you were saying before, because I want to underline this for them also. When you have your paternity or divorce case flowing forward, and maybe there is no second case, there is no case that has been brought by the department in front of the child support hearing officer, but Department of Revenue is still involved. And the typical with the person who's wanting the child support. Department is it's still a Title IV case. Talk to the lawyers, because there's not always an intervention. If the department moves to intervene in your case, you're going to know it, and they're going to notice you, and you're going to get an order, and you're going to be like, oh, it's a Title IV case. Great. That means child support hearing officer is going to deal with all my child support stuff. But what are some other clues for the lawyers when there isn't something obvious like a motion to intervene?
The first and most important thing that you can do is to talk to your client and make sure that you ask your client, are you or have you applied for benefits? Medicaid. There are a lot of people on Medicaid. Are they getting food stamps now, or have they received food stamps in the past? Are they getting cash assistance now, or have they received cash assistance in the past? If that is the case, there is a very, very good likelihood, about 99.99%, that the Department of Revenue has become involved in that case. If there is an existing order, the Department of Revenue will take that order, will load it into its system, and as long as it doesn't have to come to court, it will enforce that order by all of the administrative mechanisms that it has available to it that the statute allows. You may not see anything in the court file about that. Typically, if the department knows that there is a court file, and we may not know because she went to DCF and she applied for these services and then decided that she didn't want to cooperate with the Department of Revenue, but there is still an assignment. If we know that there is an order, then the department files a redirection notice with the clerk of the court. And you can actually look at the clerk of the court's website now and see that there is a redirection notice for the support payments from the custodial parent to the department so that the payments are processed that way. So you can look at the clerk of the court and see if there is a redirection notice. If you see one redirection notice, that means that we got in. If you see a second redirection notice, it probably means we got out of the case. But it's looking at the clerk of the court. But more important than that is asking your client to tell you if they were involved with the 4A agency, DCF, not DOR, because there's an automatic assignment from DCF to DOR, and they don't like us. So they probably didn't even come to the Department of Revenue. They refused that interview over there. That does not mean that there's not an assignment of rights.
Sometimes it's as simple, I mean, I'm in the same position, at least initially. Now, of course, I've got Noberto Cats on my speed dial, and so I can find out pretty quickly whether a case is DOR. But some of the things I look for are, did DOR request copies? That's a line item. I look at the affidavits of arrearage. There's often little, DOR codes and things like that that you can see. But really question your clients about this hard, because the worst thing for you is to end up in front of me and find out at your trial that I'm not dealing with a big fat issue that you thought you were going to get done that day. When in doubt, if you really are confused, email my office. I'm happy to let you know. I don't like telling people in the middle of their final trial that I'm not going to deal with something that they thought I was going to deal with. I'd much rather have you know that at the get-go. Sure, absolutely.
And kind of in the same vein, if you've got a time-sharing issue that's pending and you haven't resolved it, or you're in the midst of resolving it, don't wait until the trial to come in and say, well, Mr. Katz, we have a time-sharing petition that we want to have resolved when I've already set your trial. Be proactive about that. If you've got a separate, if you've got a DOM pending or something pending that deals with time-sharing, which is going to affect the child support, that has to get done on the front end, on the back end, because if not, you have to come back for a modification. So be proactive in the same vein, because we deal a lot with that, when people come in and say, we've got a petition for time-sharing pending, and right now we need to wait until that's resolved to do the child support. And then I've got everybody in the room, and the trial's been set for a long time, and the case is pending. And I just want to note also, it's kind of important that you all know that the circuit and Mr. Castro and DOR are bound by certain federal guidelines of when to close cases, and we need to be mindful of that, because that does get looked at. So we have a period of time that we're supposed to do the case, and if we fall outside of those guidelines, we need to basically explain why, or document why. So please keep that in mind, because we need to keep with it, at least try to keep within those guidelines. So if you have a time-sharing case that's about to go to mediation, and you get set for a trial in front of me or the hearing officer, you want to be proactive about getting in, filing a motion for continue, letting Mr. Castro know, so we're not having to do this twice.
All right, so the flow of that then should look like, if you get involved in a paternity or divorce case and you find out by some way or method that it's a Title IV case, that the department is involved in some way, even if they have not filed an intervention, if they are dealing with child support, then you would bring whatever that action is, paternity or divorce, to me. I would deal with everything except for child support. And in my world, child support includes tax deduction issues, division of uncovereds, all of the kind of tangential to child support issues. And then I would, in the final judgment, say that the department is enforcing this. Those issues will either be dealt with in that separate DOR case, or those issues will be dealt with by the child support hearing officer. Now, I have had, and I'm going to have a conversation with you in front of God and these witnesses on a couple of issues. I have been asked by lawyers whether or not I can / will make findings related to the data that goes into the formula in order to make their trip to your hearing easier / better. I'd like your thoughts on that as to whether that's helpful, not helpful, something that you would be bound by, feel bound by.
Well, the answer to that is I'll do what you want me to do, okay? Because you're the judge and you get the final determination and we do a report recommendation. But on a more serious note, from my perspective, the more information I get from you in terms of findings, the easier it is for me to get my job done at the hearing. So I welcome that, and you have done that in the past, and I think that's totally acceptable. The only hiccup might be if you're making some type of a finding that DOR might be objecting to.
Right.
That might be the hiccup.
And so that's, I mean, honestly, that is my issue with it also. And I don't know that we may be able to develop some standard wordage that would deal with that problem, because I don't want it to be taken as a directive without the department having had their say, but to the extent that it can make your jobs easier, I want to do that. So that may be something that we can talk about and develop and have some continuity so that you would not take it in a way that was further than I meant it.
Well, I think there's certain findings that you can make that would assist me. For instance, the issue of split custody, those kind of issues, and the time that, or a finding of during the pendency of your action, if the parties were residing together and when they separated, those kinds of things would be helpful to us, because that's often a point of controversy. So if that is resolved on the front end, that makes our life a little easier down the road.
So that makes, actually, that makes a lot of sense. If I'm going to be doing time sharing, then I would assume that it would be my obligation to let you know what that number of overnight split is.
Correct.
That makes sense. And if there's some difference in time periods, that makes sense also. So assume for a moment a fact pattern where the department, on behalf of mom, they file a paternity action. It goes to the child support hearing officer, and you set child support at $500 an hour. I mean, at five.
No, that's what Judge Tennis used to earn when she was in private practice, right?
Nice work if you can get it. $500 a month. All right, and then one of the parties, either before that order is entered or after that order is entered, files a paternity or divorce case. It goes through to conclusion, and I enter an order giving 50-50 custody.
Right.
Which dramatically changes that number.
Correct.
When they come back to you for a new calculation, what date do you use to modify that back to? Do you use the date that I entered that new time sharing? Do you go back to when they filed their petition for dissolution, or?
I normally, unless there's some fact pattern that doesn't call for it, I would go back to the date that you made the finding of when that time sharing started. Now, there's an argument to be made, and maybe Mr. Castro will make that, is that the modification, that would have to be a modification, by the way.
So when you let's define our terms here. If you enter an order, and we'll leave the bill 950 to the side for just a moment. When you enter an order originally,
Right.
typically, and I know typically,
Right.
you will not be taking into account substantial time sharing unless the parties agree that that's what they're doing.
No, actually, we do look at time sharing now.
Okay.
There is a series of questions that are asked about time sharing. We are covering that in the original hearing.
What if they disagree and you couldn't possibly figure out who's telling the truth about what they're doing for time sharing?
If they disagree on what time sharing they're exercising?
Yeah.
Well, it's a credibility issue at that point, and I'll just do my best, take my best shot at determining what I think is the right amount. And I always say to them, if you guys can agree on this, then you need to file something with the circuit judge and get this straightened out so that can be dealt with.
All right. So assume for a moment that you have a paternity action. Paternity has not been established. You can't establish paternity.
Yeah.
That's another seminar. That's a long one. So you, and mom says, I think he has drugs. He doesn't have time sharing, and he says, I want to have time sharing. So you're gonna do child support based on him not having substantial time sharing,
Correct.
right? All right. So say he files a paternity action in circuit court. I hear that 6 months later, a temporary, and I give him 50-50 at that point.
Right.
So, and then on a final, 6 months after that, he still gets a 50-50. I want to clear here. My understanding is when it comes back to you for your final child support determination, that he doesn't have to prove a substantial change, that it's not the substantial change petition for modification burden. It's just here, this isn't what you were using before.
No, it actually is a substantial change in circumstances, because that's the term of art. But if I have never seen DOR object to a modification based on a new time-sharing order that's been entered by the court, that in and of itself is
a substantial change.
So that's not an issue.
And so you're going back then to the temporary? Are you going
I
back
thought
to
your order was final.
Well, I did a temporary and then a final. Are you gonna change the child support back to when I entered the temporary?
No, I would go back to your final order.
Okay.
Because it's not final until, because here's the here's the rub with that. DOR was not involved in your time sharing case, so the finality, the substantial change is the final order of time sharing, not the temporary order. I guess, there could be an argument made that they should be entitled to some type of a credit for that period of time, if they were exercising it, if they were actually exercising. That would be the argument, is for a credit during that period of time, which you can cover in both. You could file your modification and for a credit during the temporary arrangement.
All right. So, I think that's an interesting question. In my mind, I think it's arguable that at the point they actually are doing 50-50, because I ordered it the temporary, that should be taken into account from that date. My perception is, even when folks are not filing a separate motion to modify, motion for, in Orange County, I think they're calling these superseding, even when they're not filing something in your paternity case, that you are still utilizing what's going on in the divorce or paternity case in circuit court to make those changes, even without a modification being pled, is my perception.
No. If there is a final order of support, that order is in effect. They have to come back on a modification. What I was talking about earlier is if there is a pending action, and then a pending DOR action, which I'm involved in, and the parties have filed a petition for time sharing or a dissolution, that's what I'm talking about. And then I would wait until that's resolved with your findings to do a final order on support. So that we're talking little
Right, right. So if you have entered in your mind a final order of support, and using our last hypothetical, assuming is 0 overnights and not substantial change, and then he files for a paternity, gets a temporary order saying 50-50, gets a final order saying 50-50. What I hear you saying, but I just, this wasn't my understanding of what was actually happening. What I hear you saying is they actually have to file a motion to modify in your case.
Right, because
Okay.
DOR, the reason is because DOR is not aware and involved. So you've got to put DOR on notice in some fashion to be involved in the support case. They have to come back to the support case.
I think I just assumed that they were filing notices requesting hearings based on my order referring the issue back to you, and that you were dealing with that issue without them filing modifications.
Now, if you in your final judgment direct me to recalculate child support, then I can do that.
Okay. So I think for the practitioner, what you need to understand is that if you don't file a modification in the DOR case, you probably will be able to convince me to ask them to recalculate, but you may be stuck with a recalculation only back to the date of the final judgment, which could be a long time. So I think the better course of practice would be, when you know that there's a DOR separate case, file a modification action, and understanding we're calling it a modification, we're calling it a substantial change in circumstance, but the reality is since the department and the hearing officer has never been able to really deal with the overnight issue, that determination by the circuit court is always, I think we're all on the same page, is going to be a substantial change in circumstance, and it's going to get recalculated. Does 950 have enough life in it that it's worth talking about?
Well, here's where about the time. Okay, so I don't know if you all know about this, and we'll fill you in. And have been involved in this knee deep because of my involvement with the legislative committee of the family law section. But there is a bill right now that says that in administrative support cases that I'm sure Mr. Castro is going to talk about, which is the bane of our existence, and let's be honest about this, because of the difficulty in not in the statute itself, but really dealing with it, that there is a bill pending, it's actually been passed by both houses, that allows for a visitation, a time-sharing schedule to be done at the same time the administrative support is set by the administrative court. As you can, I can see from the reactions in the room, the few of them, with your eyes open and with your head shaking, that is a ticking time bomb that is going to explode. It is now before the governor. Interestingly enough, and I'm sure Mr. Castro can elucidate if he wants to, DOR was not opposed to this statute, which I would have thought would have been the opposite, because for years when I was starting this job, for many years, I heard we don't want to be involved in visitation or time sharing, visitation in those days, time sharing. So that bill is in front of the governor right now, as we said, it's at his desk. Whether that's going to pass or not is depending on what time of day it is. We are lobbying heavily against it. We've been told that the governor is considering it and has not made up his mind. If that bill passes, things are going to. By the way, so to go back, and I'm giving you about 6 months of work that we've done on this bill. Both parties have to agree to it. Okay, so it has to be done by agreement of both parties. All right, and it's not anything like a parenting plan and time sharing order or agreement that you all would do. It's a very, very basic type of thing. The problem is going to be when, and this is what we've discussed, is who's going to enforce that? Because the administrative, unless that order becomes an order of this court, and then that opens up a Pandora's box, whether the circuit court has the ability to modify that based on what we're governed by under the statute. By the way, this parenting plan does not have anything to do with the statute as it currently is in place on the Chapter 61. So how are we going to deal with it? Because who's going to enforce it? Is the DOR now going to enforce the administrative time-sharing order? We don't know. That's something I don't know. I don't think anybody knows. So these are the questions that are being asked. I would say read the bill, familiarize yourself with this, and just hold your breath to see what the governor's going to do with it. Within the next, I'd say, 30 to 45 days, you'll probably have an answer. But if it does pass, you need to be conversant in this, and you need to, it depends on when you get your clients in, but, this is not going to be a time-sharing bill that's going to be fair to both sides. I can tell you that right now. And the other problem is that it does not take into account any of the other factors that the courts deal with. That is a big problem. There's no domestic violence indicators in this thing. And as we all know that have been around the block once or twice, that does happen. And sometimes there's a power issue. Sometimes there's a manipulation issue. Those kind of things are not ever going to be looked at in this thing. So it is problematic. That's really all I can say at this point.
I think the odds of it getting signed are really rather minimal. But if it does, we will be having a emergency stat seminar, what the heck, ASAP. So stay tuned. Did you want to add anything to that particular issue?
Well, I just want to say that they never talked to me about that stuff.
Well, I was told that you were intimately involved in writing this statute, Mr. Castro.
Time sharing, that's what I heard you were saying.
That's right, that's right. Yeah. I don't know. If it does become effective, it becomes effective January 1st, 2018. The department, it's over $1.5 million that has been appropriated or supposed to be appropriated for this. And I think that's the biggest sticking point, whether or not there's money. And this is state money, it's not federal money. We run on federal money. This is state money because actually this is a deviation from Title 4D of the Social Security Act. Title 4D says you can only deal with child support establishment, enforcement, and paternities and modifications. It excludes time sharing. This is based upon a model from Texas.
So you know it's good.
It's they've been doing it over there since 1989, and they have gotten away with it. So Florida now thinks that it can get away with it too, and now run afoul of the federal regulations. So I don't know what's going to happen with it, but if it does happen, I guess we'll have a seminar and figure it out.
You will sit down and figure it out.
Yeah.
So I want to have us talk now about the more confusing type of child support order that you're going to find in your cases. So we've talked about the ones where the department is either getting involved in your case because it's become a Title IV case, or they're filing their own case that goes in front of the child support hearing officer. I'd like Hernan to talk to you now about the administrative child support case and how that comes about, and we're going to talk about how it's different. It's extremely different, so you need to be able to figure out what is what when you look at those orders.
So this is the product of legislation that was originally passed in 2001. It was a pilot in Volusia County, and then in 2002 it became statewide. Is the administrative enforcement or the administrative establishment of child support orders. What the statute does, and it's 4092563, what it does is that it empowers the state agency, the Department of Revenue, to establish support obligations to begin with through an administrative process. This is not new to child support law. Those of you that are practicing family law today, if you went to law school when I went to law school, which was too many years ago, you were told that family law was a state matter and that the federal government didn't get involved with that. Well, 1974, the Child Support Enforcement Act is passed. It's mandated upon the states. In 1984, they passed a law which says states, you're not acting fast enough, and you have to now establish extrajudicial processes for establishing and enforcing support orders. And if you don't want to participate in that, you have to ask for an exemption. The genesis of Rule 12.491 is there. In 1986, Florida passed a law adopting or acquiescing to what the federal government had said, and as a result of that, the Florida Supreme Court came up with Rule 12.491 to try to expedite things. And that's the genesis of the hearing officer rule, which has been adopted in this particular circuit. Apparently, we weren't working fast enough. And so in 2001, the Department of Revenue decided to go out and establish its own administrative process. I can tell you today, 55% of the cases that are being handled by the Department of Revenue to begin with are handled administratively. We used to file those cases in the circuit court. Now they are being handled administratively. So the chances that you are going to see clients that are going through this process, it's ever increasing. And it's only limited by the computer system that the department has. So this is how it works. Chapter 4092563 allows the Department of Revenue to send a notice to someone who is supposed to be paying child support, as they have determined it, who has no court order for support out there. So they look and see there's no order for support, then they say, okay, this qualifies for the administrative process.
Can back 1 second. So, mom wanting child support comes knocking on DOR's door. What determines whether you all file a petition that goes in front of the child support hearing officer, or they decide to go this administrative, not in the courthouse route?
They're required to go administrative first by the department rules. So they go through the administrative process. Typically, the administrative cases are what look like the easiest cases. If they have complications, if they have pending cases, if they have disputed, complicated paternity cases, they're going to send them to circuit court. But if it's your run-of-the-mill, mom and dad got together, they fathered and made a child, and he's not paying, it's going to go administrative. And so what they do is that they send the obligor a notice to commence proceedings. And what they also do and are required to do by the statute is to file that notice to commence proceedings in the circuit court. It gets a circuit court case number, but it's not a circuit court case. The only reason why it has a circuit court case number is so that money is processed through there, through the state disbursement unit.
In other words, don't file anything in that case number. It's just a mirage. It's not a case. Don't file anything there.
Yeah. The clerks assign it a DR number, but it's really, you should know, if the first entry that you see in a case is notice to commence proceedings by the Department of Revenue, no summons, no complaint, just a notice to commence proceedings, that's a pure administrative case under 492563. Once that they are allowed to send this notice by certified mail, returned receipt requested, restricted delivery, which means that only the person to which it is addressed is supposed to get the notice. If they get the person on the hook, that's enough for service of process. That notice to commence proceedings gives them a whole statement of rights, and it tells them what's going to happen. Things that are going to happen are this. We got you now. You have to tell us your name, address, and phone number. If anything changes, you have to file it with us. If you don't, we are going to assume that you are getting your mail where we got you served, and we're going to send you every other paper, in this case, to that address. A lot of times as people get served, says, I'm out of here. They're gone, and when they're gone, they don't get their mail anymore because they don't want, and then they trying to figure out, oh, what happened? How did I get a child support order? That's one thing that they tell them. The other thing that they tell them is that they have the right to opt out. And I want to talk to you about this because there's a lot of confusion in the bar about this. There are 3 methods by which you can opt out of the administrative process. The first one is not a real opt-out method, but it's a way to get rid of the administrative order. And that is to file an action in circuit court and ask the circuit court to enter a superseding order. That can happen at any time. You should know that a superseding order does not have to modify and meet the standard modification requirements. The circuit judge has jurisdiction to, at that point, assess what the parties' support obligations should be pursuant to the child support guidelines without the necessity of pleading or proving a substantial change in circumstances.
So I've got a question. So my understanding, guy gets the notice, we're going forward administratively. One of his opt-outs is filing his own paternity or divorce action in circuit court. My understanding, though, is that the administrative process doesn't have to stop necessarily until he gets an order on support. Is that true or not true?
Under that quasi opt-out provision, that is correct.
Okay.
The other way that he can...
I mean, you got to get a child support order before they finish up their business.
Yeah.
It's whoever gets the order first.
The real opt-out process is that once they get that notice, they have 20 days from the date of receipt of the order to file an action in circuit court and also serve the department with a copy of that notice.
This is the part that doesn't happen right. So, in other words, got up and said, no, I'd rather go deal with this with my divorce case or all my other paternity stuff. I'm going to go file my own circuit court action. If you serve Tallahassee, I mean DOR, and I don't mean Hernan Castro, I mean DOR, if you serve them, you've really opted out, and they will dismiss that administrative proceeding. If you don't, then you may still be able to opt out if you get a child support order first.
Okay. The Department of Revenue, when the statute was passed, and if you read the statute literally, it says serve the department. It didn't say how the department had to be served. You should note that there was a case decided on October 7th, which went against the department's interpretation of the statute, and now says that, contrary to the information that we gave you at the last time that we had a seminar, that service on the department can be made pursuant to Rule 12.516, which allows you to do it by mail to the address that they sent you in the notice. And that's the Johnson case, Department of Revenue versus Johnson. We took it up on appeal and lost it. First DCA said, no, department, that's how you serve them. You serve them by mail. That's how they're going to serve you. They can do it by mail. So you can file a circuit court action. You have to do it within 20 days, and you have to serve the department, use the same address that they send you in the notice. Okay? And I would, then after that, you're out. You're opted out of the administrative process. The other way to opt out of the administrative process is not to file your own action, but you can say, hey, DOR, I want you to file an action in circuit court. You can tell the department that, or you can tell the department, I want to litigate issues of time sharing, and I want to litigate issues of paternity, or I want to litigate all those other issues. I want you to file an action in circuit court. If you do that, the department will send you, you have to do it within 20 days, and they actually count those 20 days. If you're 20 and a half days or 21 days, they won't allow you to do it. But
And we're using the word they. This is like a big computer. This isn't Castro's office. This is a big computer somewhere spitting out the things as it spits out the things. So it's not, you're not dealing with people at this point.
if you do that within 20 days, what the department will do then is to notify my office, ask my office to file an action in circuit court. We will file an action in circuit court and send your client a waiver of service of process. Your client has to return that waiver of service of process within 10 days. If it's not received by the Department of Revenue within 10 days, they don't opt out. They're still in the administrative process.
All right, and then let's talk about reality. The respondent didn't do nothing. Then what happens?
Didn't do anything. So they got him on the hook, they got him served by certified mail, and he didn't do anything. He just goes about his business. The department then gathers information. They may get a financial affidavit from the mother. The thing that they do typically is that we have access to the to tax information. We are able to look if the person is working above board with a Social Security number to know how much it is that they're earning. And so we use those numbers. The department uses those numbers to compute the child support obligation, and then they send them a proposed order. When they send them a proposed order, it's too late. If you see a proposed order, they cannot opt out. They have waived their time period to begin with. By the time they get a proposed order, the department is going to move forward to establish a support obligation, even if you filed an action in circuit court subsequent to that. Okay? So they get a proposed order. They either like the order and don't do anything about it, in which case the agency signs off on it, or they have 20 days within which to ask the department to send this to the Division of Administrative Hearings. If it goes to the Division of Administrative Hearings, that is a quasi-judicial process that operates under Chapter 120 of the Florida statutes. They actually assign a judge from Tallahassee. We have one here now as a general magistrate. Jeff Clark did it for many years. They actually assigned an administrative law judge from the Division of Administrative Hearings. They have to have essentially the same qualifications as a circuit court to be able to have that office. And they they do a hearing on the Chapter 120. The rules that apply are the rules on the Florida Administrative Code 28-106. Okay, so there are specific rules of procedures that apply to this type of processes. We go in, typically this is at the Hurston Towers in Orlando. We have a hearing in front of an administrative law judge. The hearing is a lot like you have here in circuit court or with hearing officer Katz, with one huge exception. Hearsay evidence is admissible in administrative hearings, as long as it's not the only evidence upon which you ground your ruling. You can use hearsay evidence. So, the hearing is concluded. The Division of Administrative Hearings judge signs an order, sends it to the department renders the order, and that order is now enforceable in the exact same way, with the same force and effect as a judicial order. The only difference between that order and a judicial order is that it may not be enforced by contempt of court. For us to be able to put somebody in jail for violation of that order, we have to go to Mr. Katz and say, Mr. Katz, would you please bless the order? Once he does that, he sends it to the judge, it becomes a judicial order, and then the violation of that judge's order is what we ask for contempt on.
So again, this is the 409.2563. If you see an order that says final administrative order, that's the thing we're talking about. It's totally different. The route to getting there, totally different than in court in front of child support hearing officer, still binding. The way to get it changed is totally different. You must read the statute. And what are the highlights and lowlights? There's some good side, there's some upsides and there's some downsides to the process to getting this changed. Once you find out 8 months after you've been in the case that this thing is out there that your client never told you about.
The circuit court has jurisdiction to enter a superseding order. You file an action for a superseding order. Be sure that that action is filed and that you attach a copy of the administrative order. Section 14 of the statute tells you what you have to do. You have to attach a copy of the order and you have to serve the Department of Revenue. You have to let the Department of Revenue know. When you do that, then you can ask the court to enter a superseding order. Again, that superseding order is a de novo determination of the child support obligation. The court can then prospectively change the administrative support order, the amount of child support, back to the date of the filing of the petition for superseding order.
But do not talk to the hearing officer or the judge about arrears that are accrued in the administrative orders. Those are vested rights. Those cannot be modified by the court. So, and that's in the statute, I believe.
Correct.
So you got to be cognizant of this. So time is not on your side. If you're dealing with these administrative orders, it's accruing until you get into circuit court and you get that superseding order. And that's a big, big, big misunderstanding that people come in and say, well, they were living together, or the administrative judge didn't take this into account, or he didn't ask them about time sharing. I'm sorry, that issue is res judicata. I cannot touch it.
And the thing that I am bothered by is folks, even some folks that mention this in their petition for paternity or petition for divorce in front of me are not asking for a superseding order. Now, I'm pretty lax when it comes to that language. If there's any way I can torture your language into doing what you're supposed to do, but that's easily challengeable. 409.2563 tells you exactly what you've got to ask for, and you're supposed to be asking for a superseding order. You're supposed to be attaching a copy of the order. So beware of that. That's a statute you all need to absolutely read and be familiar with.
Don't come to court and file a 1.540 motion for relief from order. It's not a judicial order. The court cannot give you relief from that order. Don't ask the judge, well, judge, I didn't consider, the fact that they were living together. They just give me another order. No, the circuit court doesn't have jurisdiction to do that. We have a case that came out right out of Osceola County where a sitting circuit judge decided that he was going to set that order aside. Can't do that. The only remedy that you have from an administrative support order, once it's been rendered, is to file an appeal, either on the Chapter 120.69 or to file an appeal to either the first DCA, which is where the agency resides, or the fifth DCA, which is where your client lives. So it's the DCA that has jurisdiction to change that administrative order or challenge it, not the circuit court judge. So you can't come to court and ask for relief from the administrative order in the circuit court. You can ask for a superseding order, but not for relief from the administrative order.
So again, on those administrative orders, you can ask for superseding order. You can go to either child support hearing officer or the circuit court. I believe you can ask for that superseding order within your paternity or divorce action, but please look at the statute as to what needs to be included in that, and you cannot get it back any farther than when you've asked for it. Yeah, questions?
I had the exact same situation, have an administrative order, and understand I need to ask for a superseding order, but now I've got a temporary time sharing plan in place. So I want to not get relief from that child support. Would it be the same as what we just talked about?
I think what you're asking is, can you get kind of multiple superseding orders? I think once, if you're in front of the circuit judge, if you're in front of me, and you're saying, I've just gotten time sharing, I'd like a superseding order, and you go through, you put in there what you need to have in there. Once I change that order, it's now my order. Right. And yes, I can change my order from the temporary to the final, and you don't have to continue asking for the superseding. Once it's changed, then it's my order, and I'm just going to be changing it because I'm entering a final order ultimately rather than that temporary.
The other thing that I wanted to tell you, and that there's not a lot of people do not know about this, an administrative order, once rendered by the department, it's good, it's still there. The department may get out of the case. She may tell the department to close its case. The order is still there, it's still good, it doesn't go away, and you have the right to enforce that order yourselves. You can actually go to circuit court and ask the circuit court for an enforcement order of the administrative support order, and your client then has a child support order. Okay?
That's a really good point. Yeah, question.
In a situation where the child is no longer a minor and there are arrearages that exist in a case with DOR, I'm assuming it will be a Title IV case. Does the parent have the ability to just opt out and say, hey, I don't need services anymore and I just want to dismiss this whole thing?
Maybe. And again, we have to be equivocal because every case is different. Most probably, but, and I get this all the time. I want to forgive the arrears, you know, he and I are getting along, or we've reached an agreement between ourselves, we don't want anybody involved, and I have to look at what's in the best interest of the child. So, and I'll tell you what I've started doing typically, because I've had issues with this in the past, is if the child is under 18, I usually don't forgive the arrears. I tell them to come back after the child is 18 and reach majority. At that point, then I can make a better assessment where did everything work out, was it fair, and then at that point I would look at forgiving the arrears. The rub is, again, what we talked about a lot earlier, which is if there are state benefits that have been paid and the department has a vested interest in those state benefits, I don't think I have the authority to waive those. So you've got to be real careful about that. And you could probably inquire of the department, because we have what we call PA arrears, which are public assistance arrears, and we have non-public assistance. So you really need to find that out, because the public assistance arrears are not going to go away. That I can tell you for a fact. The non-assistance, again, depending on the facts of each case and whether that's warranted, and the amount and all those kind of things.
Any other questions? Yeah. Sure.
I took some notes. I want to make sure I'm clear. If a parent just simply gets the department involved in collect or enforcing child support, does that qualify as a Title IV situation?
Yes. Now, I think, though, but I'm glad you brought that up because I thought to mention this earlier. I think in those situations, gentlemen, correct me if I'm wrong, when there are no, when the state doesn't have a dog in the ring because they haven't given any assistance, if that same person decided they wanted to fire the department and get their own lawyer, a different lawyer, and take that issue then in front of the circuit judge, I believe that process is typically, done and not a big deal. And so they would let the child support hearing officer know, and they don't care because they don't have any money outflowing to that person. And he basically kicks it back to me, and I say, oh, well, I guess I got to do my job now, and then I'll take it on.
Yeah, I'm, and we're trying to be as diligent as we can given the amount of work we have. But when I get motions from attorneys on enforcement or post-enforcement, I usually check to see if DOR is still involved or not. Because if it's not, then it has to go to the circuit judge. But I check on that just so you all know, as a matter of course.
Typically, if there's no cash assistance that has been paid by the state, we don't care. We've got too many cases to worry about it, and they want to waive it, it's up to them to waive it. There was one other thing that I wanted to mention about the this administrative cases. When you look at the clerk of the court's websites, make sure you understand the difference between the administrative case, and it's not an administrative case if it went before the child support hearing officer. And we got an order over there. That's a judicial case. It's not an administrative case. That's subject to the Florida Rules of Civil Procedure, and it follows in that fashion. It is only if it is a 409-2563 that those special rules apply, and so on. And there is a huge distinction between those two. Do we have a little bit of time?
Well, what I'm going to do is I'm going to give the number one more time, and then if you need to go, please feel free. And if you want to stay, we'll continue talking for a little bit. So one more time, the CLE number is 170-291-4, N as in Nancy. One more time, 170-291-4, N as in Nancy. Go ahead.
Okay, the other thing that I wanted to tell you about and this is a recent case, this was decided on December 12, 2016, and it actually happened with one of our cases. The other thing that attorneys do all the time when they get in front of the DOR judge is to say, Judge, I've got a circuit court case. We're about to get an order in this thing. I want you to stop your process. The judge that was sitting in this area would normally stop the process, saying that I'm going to defer to a circuit court to enter that order because the attorney is about telling me to do that. The department took an appeal from that, and the first DCA ruled just recently that no, it's error for the administrative law judge to do that. If there is no support order in place, you have to move forward, and they have to enter an order.
So again, we're talking about the administrative process and the race to the courtroom. It's whoever gets their order first prevails in that situation. It doesn't mean if you lose to the administrative process, meaning they get their order first, it doesn't mean you can't get a superseding order. It just means you can only do that prospectively. Yeah.
And that's only after the 20-day
Right.
opt-out period.
Correct.
As a follow-up on the 20-day opt-out period, if you already have a divorce pending, the other party went to you afterwards, didn't tell you, oh, there's a divorce pending, they hire you for the admin. Do I just reserve the petition on you even though I've served her?
You can do that. You can do that. You can say there's a pending circuit court action. Take notice of that. I want you to get out. But you have to do that within the 20 days.
Right. And I think there's some, I feel like there's a little bit of confusion about that because the situation he's talking about is there's a divorce pending, and then they go to DOR, and the administrative process starts. They can't file in circuit court and serve because they're already filed. So I think wouldn't you be better off filing it amended and actually serving them? I'm just worried about sending them notice isn't serving them with your circuit court circuit court pleading. I'm concerned about, I've got a question in my mind as to whether to take advantage of that opt-out, you actually need to do an amendment and have them served versus just give them notice. If you just give them notice, I'm not positive that you wouldn't still have two things pending. You think giving them notice of an already pre-filed, a prior filed petition would be sufficient?
I think so. That's the way
Okay.
I interpret the statute.
Okay.
I may be wrong, but I used to agree with Judge Parrish on this too.
Okay,
And then the first DCA said otherwise. But I interpret the statute that way.
okay. That's a good question, yeah.
As a follow-up to that same question, it doesn't matter which party was the petitioner in the circuit court case, as long as there's a circuit court case that exists, and you have notice of it.
Circuit court case that exists, don't, if you send it to me, I'll, as a professional courtesy, I will send it to the Department of Revenue, okay? To be sure, follow the Johnson case, which says you send it to the department at the address that they provided you in the notice. That's the address to which you serve them, and if you can prove that, I think you're out.
And to follow up on that issue, if you decide to get involved in the administrative hearing, I don't know why you would, but if you decided to do that, don't e-file them through our portal. They got a whole different thing going on. It has nothing to do with anything that goes on here.
Yeah,
at the courthouse.
DOR has their own portal. You
Yeah.
have to get your own
They
password
got
there.
their own portal. Yeah.
Oh, I should have just said that. You guys needed certified mail or anything like that.
You know, if I was in private practice and I was doing it, given the Department of Revenue volume of cases, I would do it by certified mail, return receipt requested.
Will they sign it? Yeah.
Yeah, they do, they sign it, they will sign it, yeah.
Any other questions? Yeah.
How do you modify an administrative order? Modification.
So that's, when you're talking about an administrative order, we use the word superseding order. And you follow that process.
You have to start with that first.
Yeah, you can try to go back to the administrative process, but if you want to get it done, it's what we've been talking about for the last 20 minutes or so, is the magical word is superseding order. That's your magic pill, and that's going to take care of the problem and get you guidelines based on current financial circumstances.
I'll tell you about a horror story about that happened with that. Someone asked the Department of Revenue to modify, because the Department of Revenue can, as long as it's not superseded by a circuit court, the Department of Revenue can modify its administrative order. Somebody went to the Department of Revenue and asked the Department of Revenue to modify its order. The Department of Revenue entered in an order that said, no, you don't qualify for modification. That guy decided that he was going to appeal that. He appealed it and he went to the first DCA. The first DCA said, that's right, you cannot, well, let me take you back a little bit. He went ahead and said, I want a DOR hearing now because you're taking administrative action. Give me a DOR hearing. The judge at the DOR hearing said, yeah, Department, you're wrong. You should have modified this order, and I'm going to modify it right now. The Department of Revenue took it up on appeal and said, no, DOR, you don't have jurisdiction. All you can do is to tell the agency to modify it according to its processes. You cannot take it upon yourself right now and actually do the calculations. So best thing to do is to come to circuit court and ask for a superseding order as opposed to, and it's a de novo proceeding. It's whatever the circumstances are at that point. You don't have to
prove substantial change, but you only get a perspective from the date of filing of the request forward. That's the downside. And in my experience, these people have let this thing just fester for years. So now, am I required, are we, in entering that superseding order, we can't touch the arrears, are we required to set a payment schedule, or are we not required to set a payment schedule?
I think once we enter the superseding order and we adjudicate the amount of arrears, we do have, I think, the jurisdiction to deal with the actual payment of that arrears.
Do we have an obligation to set a payment schedule?
Well, I think under statute we do. There's an existing arrearage and we have to deal with it.
Yeah, I
We're
think
gonna
that's
do
probably
them
true.
a disservice if we don't.
I think that's probably true. I think that's where I think the discretion comes in the fairness of what to make that number, and that would probably depend on a lot of things. Like,
Except it's,
Did they-
and the department's gonna fall back on the 20%. That's gonna be their fallback position of the ongoing. So, but again, there's
Right.
an argument to be made on repayment, given the new amount and given the circumstances of the parties.
Question?
That kind of goes along with my question. I work with legal aid, and you get a lot of veterans who they were dealing with PTSD, homelessness throughout the child's entire childhood. You know, the kids are my age at this point, and they want to modify the child support amount. So it's not obviously based on substantial change. So it'd be based on that.
Wait a minute, they want to, the child's over the age of 18?
Yeah, kids in their 20s.
You're done. All you can do is negotiate a repayment of those arrears. Those are vested arrears.
Right, no, of course, and I always tell them that, like, you know, if the arrears is gonna be 30,000, sorry, but we can, what
Yeah, you
we
have,
based on-
the court has jurisdiction on the repayment of those arrears, and you can come in and make argument on that.
Okay, just explain the
Yeah, you'd have to put on, you basically have to put on a case regarding the financial circumstances of your client and why the court should do with that. And I would strongly urge you to make some type of a recommendation what you think a repayment plan should be.
So are you talking about a final administrative order, or are you talking about
Right.
either that or the other kind?
Usually, they've been held in contempt 5 times, so it's already.
But we still need to know the answer to that question because
Right.
it's different, the answer may be different as to what kind of an order it is. If it's a judicial order, no problem. If it's an administrative order, you've got to go to that first step, which is, Hernan mentioned it, which is you got to have it enforced and then,
Usually it's with the court, usually.
okay.
It's already told.
Well,
I'm sorry.
No, so just because it's been enforced doesn't necessarily mean it started as either an administrative order or it started as a paternity order in front of the child support hearing officer. The difference is if it started as an administrative order, then you can bring it to either of us. If it started as a DOR case in front of the child support hearing officer, you have to take it back to the officer. That's the distinction.
There's one thing, when you're talking about arrearages, that it's specific to Title 40 cases. And you will see this, and people come in and complain all the time, attorneys and clients and everybody else. When a child support order in a Title 40 case ends by virtue of the emancipation of any of the children, the statute is 6114 subsection 10 says that by operation of law, the department will continue to collect the entire amount that was previously ordered until the arrearages are extinguished. So 3 children in the case, it's a step-down order, but he has arrearages, the first child emancipates, we continue to collect the entire amount until the arrearages are extinguished. And that, it gets applied to the arrearages, but it happens by operation of law. There is a little quirk there in the statute that says unless the court otherwise adjudicates or orders, so that means he goes in front of the hearing officer.
So if you have that circumstance, and this happens all the time, where the person thinks they're done, they have some type of an arrearage, and they keep getting assessed at the original amount. If you have that situation, just file a motion to set arrears and reconsideration of repayment or repayment of the arrears, and then I have the ability to take a look at the financial circumstances, see if there should be a change in the amount paid. We do that all the time.
Another thing that's really important, it's in your outline, if you get an order and the Department of Revenue was not involved in the process of getting that order, be sure that you serve the Department of Revenue, make sure that they get it. The Department of Revenue has a computer. That computer is not tied to the clerical court's computers. We don't see what your clients do. That computer operates on the last entry that someone at the Department of Revenue made on that computer. It's called the contract. The contract is the order. That contract continues to click. Income deduction notices get sent out based upon on that particular contract. So you may modify your order, okay? You may have less child support being ordered in your case now. Original divorce case, we came in, started enforcing. You now modify that child support order. The Department of Revenue wasn't involved. We don't know anything about that. Guess what's going to happen the next time that we find a new employer for your client? An income deduction notice is going to be sent to that employer with the old amount because the Department of Revenue does not know about it.
So I'm gonna end on the note that Hernan was kind of talking about. The Department of Revenue does have some enforcement mechanisms that are unique and in the right situation can be super helpful. There are frustrating situations when you're trying to enforce child support where there is just not quite enough there to stick somebody in jail. And short of that, and being mean to people and awarding attorney's fees, I'm somewhat limited in those situations. The department has all sorts of fun stuff that they can do, including nabbing money from the IRS and dealing with driver's license. They have other tools in their toolkit. So if you get to a point where you feel like you just aren't able to quite get your client what they need in your contempt action, I would consider sending them over to the folks that have the other little evil ways to make things happen. They can be quite effective.
It's interesting. The DOR can suspend basically every license in the world but one, and we know who wrote the statute because that's lawyers. but yeah, I mean it's a tremendous. I mean, and you sit here and you laugh, but I can tell you I've dealt with fishing licenses. I've dealt with cosmetology licenses. I've dealt with just a myriad of things because, people get along and all of a sudden they get a letter from the Department of Professional Regulation. Oh, by the way, you can't cut any more hair, and that gets people's attention. That driver's license and that kind of motion gets people's attentions, I think, even more than contempt.
And by the way, that happens automatically. There's not a human being involved. There is a contract, an order. There is a failure to comply with that order, which the computer just adds up, and then the administrative enforcement begins. Driver's license suspensions, 15-day if you're late. That happens automatically. It's just a bunch of bolts up there in Tallahassee that send it out. Fishing licenses, recreational licenses, professional licenses, bank account levies. We're seeing a lot more than that. They hide their money someplace. We figure out there is a data match between the financial institution and the department. Bank levies. We take lottery money. We do IRS intercepts. Credit reporting agencies, so they can't go buy a house because their credit is now messed up unless they go through the Department of Revenue. Those are all enforcement tools that are available only to Title 40 cases that you do not have. So it may serve you, or it may serve your client for you to send your client over to the department. They're slow. They're not real friendly. But they do a lot of automatic enforcement, which really raises the amount of child support that's collected.
Let me give you, I just want to make one more point. Do not file motions to have passports issued with the circuit court. This is a common misconception, and if you haven't dealt with this before, and it's happened now more and more on occasion. By federal statute, if your client is in arrears greater than $2,500, the Department of State, the Department of Revenue sends, it's all the computers do it. Don't ask me how they do it, but they all know each other. They automatically suspend the passport, and I do not. The circuit court, there's case law says we do not have the authority to tell the Department of State to issue that passport. We do not have jurisdiction to do that. So if you have a client that's complaining about the passport issue, they either got to address themselves to the Department of State or they have to get their arrears less than $2,500. There is no other venue to have that fixed, and we do not have the authority. I have neither Judge Tennis nor I nor anybody in the circuit court has any authority to tell the Department of State to issue that passport.
So, yeah.
I had that issue years ago and it went on for like a year and a half trying to get this guy's passport reinstated. And he was here. And so I got orders from hearing officer and Judge Norton. Everybody was zero balance. I'm going, how do we get this undone? How do we get it? The path, it was just really a nightmare trying to get it reinstated.
I can imagine that being a nightmare.
So to contest like an administrative driver's license suspension or to reinstate driver's license, same thing with the superseding order is a petition.
No. If you have a motion, if your client gets that letter, even that letter says it. You have 20 days, Ms. Castro?
25 days on driver's licenses.
So you or your client have to file a motion in the circuit court to contest that driver's license being suspended. And we do those like every Friday.
Every day, all day.
All day. Every
Yeah.
Friday that's it.
Yeah.
A petition to reinstate, same thing.
Same thing.
It's either to reinstate or to stop the suspension
Or to
of the
stop it.
driver's license. If you
Right.
do it on time, if your client walks in the door, look at the date of the notice. If they do it within the time period that it tells them to do it in that notice, the suspension is stopped until you get a hearing in front of the court. So nothing happens until you get in front of the court. If they wait and don't do it within the time frame, driver's license is then suspended, and it has to be reinstated by the court, but in the meantime, it's suspended. And then guess what? The department lifts the suspension at the instance of the court. They have to go to DMV and pay DMV $67.
Correct.
Get it back.
So I'm thinking later this summer about doing a longer, like, afternoon seminar and talking a little bit more deeply about some of these child support, how to prove it up, enforcement, paternity, disestablishment, some of the things that, we touch on kind of tangentially in this conversation, but that might need or warrant some more time. So anyway, I'm contemplating that. Are y'all interested in doing, I know an afternoon's a lot to give up, and because it probably would end up on a Friday just because that usually works out better for folks. But so anyway, be on the lookout for that. If the governor signs something related to our issues, we will do something about that pretty quickly.
I'll know probably about 10 minutes after.
And then I should know it.
The family law section lobby. Right. Yeah. It's going to hit the wires really fast, but
So again, the only Twitter question I got has to do with the superseding. The administrative order statute we've been talking about is 409, not the cleaner, 409.2563.
right.
All right, thank you all.
Thank you.